Welcome to the podcast, ladies and gentlemen. My name is AJ Richmond. I'm a criminal defense and personal injury attorney here in North Georgia. And what I want to talk about today is pretrial diversion. Now, a lot of places in Georgia have things called pretrial diversion. They may call it pretrial intervention. Another acronym or shortcut that most lawyers use is PTD, stands for pretrial diversion. But what it is your lawyer is able to negotiate a sentence and negotiate an outcome where you most likely don't have to go through the court system. And it is a game changer in your case, and it's not a given. I've never really been to any jurisdiction where they simply say, oh, you were arrested for this, and therefore you get to get pretrial diversion. Like, you got a DUI, we give you diversion. You got a domestic violence charge, we give you a diversion. I don't know of a single place like that. And unfortunately, I have, clients call and they'll say, hey, this should be easy. I'm going to get diversion. This county offers diversion. And my response immediately is, well, that's not up to anybody but the prosecutor. And you could get a rookie prosecutor that just wants to try you in court. You can get a mean prosecutor that just doesn't like you or anyone. And you can get a judge that simply is not going to sign any document the prosecutor gives, and therefore you'll be in court. So there's no such thing as an automatic diversion. So your lawyer really has to negotiate that with the state, with the prosecutor, and figure out, okay, is this a case where we don't need to spend lots of time, lots of court time arguing, and can we really settle the case and sort of give this person a slap on the wrist? But it's really not a slap on the wrist. I mean, it is a punishment. And there's consequences to everything in that program. But let's talk about what pretrial diversion is. So number one, it's pretrial, meaning before any trial. And typically it happens usually around your first court date. If you're lucky enough, and I really try and do this, I really try and work my ass off to try and get pretrial diversion before my client has to come to court. Because I know how scared and how nervous and how anxious my clients are, and I really try and get it done before, so that way they never have to step foot in a courtroom. Now, that's not always possible, but it really is a cool thing to tell a client, hey, you got arrested, blah, blah, blah happened, you got all these court dates, but guess what? You don't have to go to any of them. So it happens pre-trial. And it can happen, the state can make that offer at any point during the case. They can make it in the beginning, which is when I like it. They can make it the day before trial. They can make it the day of trial. It really depends on a lot of factors. But generally, it's in the beginning. And then it's diversion. And that means we're diverting. We're taking your case out of the regular court system. And we're putting it sort of on the side, on the left or the right side, on the wing of the court system. And the prosecutor is saying, and we're agreeing to, basically, we won't put you back in so long as you complete all of this stuff. And then the next question, well, what's this stuff? Well, the stuff usually is almost always fines. So, for example, if you're in, really anywhere in Georgia, fines could be anywhere between $250 and $1,000, and typically the fines are up there, $500 to $1,000, and you pay that up front, and that's it. That's the cost of getting into this program, and that's most likely going to be cheaper than if you actually were guilty of a crime and you had to pay court fines. It usually comes out cheaper because there's no court costs and surcharges and all these other fees that they tack on with a guilty plea. But it's a lot of money. It's $500 to $1,000 right out of the gate. You'll have to do community service, and that's usually free work done at any 501c3 charitable organization. And it most likely will not include any religious organizations, churches, temples, mosques. You can't do it for those kind of organizations. But you can do it for like United Way, local organizations, local charities around where you live. And in all the places I practice, so Forsyth County, Dawson, Lumpkin, Hall, maybe not Hall as much, but other places, you can really do it anywhere in the state of Georgia at any charity. You're not limited to, doing it in this county. Although I've always wondered why not, but I have a whole nother view of community service. I think community service, you're doing something for free where another person who needs the money in a job can actually have a job doing that. But that's for another episode, I guess. You'll have to do most likely what's called an alcohol and drug evaluation, which is about an hour-long sit-down with a person just to determine if you have any drug or alcohol problems. You'll have to refrain from using drugs or alcohol, and you'll be tested. And the person will test you. Could be once a month, twice a month, and they'll be testing you for drug intake, marijuana intake, and alcohol intake. So you can't drink or do drugs. You'll also have to do, if it's a domestic violence case, you may have to do anger management or the Family Violence Intervention Program. We call that FVIP. It's about 26 weeks long. And that will be a condition of your pretrial diversion. There might be like a no contact with somebody. For example, if you got in a fight with someone or you did something and there's what's called a victim on the other side, you may not be allowed to have contact with that person, or maybe no violent contact with that person for a period of time. But these are things the prosecutor and your lawyer can really agree to anything, so long as it's reasonable. And there might be, this guy's a mental health problem and we need to get mental health treatment, and we know he won't go by himself, so if we order it as a condition of the program, then he'll go, and that just makes everyone happy. But really, the crux of why someone goes into a diversion program. So number one, about 99% of the time, you are not pleading guilty. So you're simply maintaining a not guilty plea. You're saying, I didn't do this, but I'm willing to do this program just to make the case go away. So that's critical. And if my clients have been through a diversion program with me as their lawyer, the first thing I point out in the diversion agreement is I don't care how much money we got to pay. I don't care about the community service hours, blah, blah, blah. None of it means anything unless the agreement says you're maintaining a not guilty plea, meaning you're not admitting to anything. And on a lot of paperwork, I'll circle it for the client and say, look, here's why we're doing this. We're not admitting to anything. And that's huge when it comes to jobs, when it comes to the military. If you have a job at a Fortune 500 company, they may ask you. But big goal for me is to make sure that you're not admitting guilt. The second thing is the case has to end with a dismissal. I'm not doing diversion to get lower charges. I'm not doing diversion to give the government money. I'm doing diversion because my client wants his case dismissed. So the agreement will do what it is we agree to if you, the prosecutor, agree to dismiss the case. If that's not a condition of the pretrial diversion agreement, we're out. So that's important. And again, that's something that I will circle and point out to the client. Hey, here is where they're agreeing to actually dismiss your case, which is huge. That's what you want. And then the third thing I don't know what's more important, the dismissal or this thing, is the record has to be restricted. Meaning, we're not just going to get it dismissed and then we're going to let the whole case sit out there for someone to look at, for someone to peruse, for someone to copy and say, here's all the other parts of the file. I want the thing restricted off your criminal history. And I believe it was episode 2, I talked about, what's on your criminal history, or episode 1. But the case has to be restricted. Too many times I have clients that may have had a pretrial diversion in the past with another lawyer in another jurisdiction who never followed up to make sure the case was restricted. But I don't believe, at least in my firm, our job doesn't end. The files don't get closed until not only is the case dismissed and we have the judge's signature, but that we have a record from the prosecutor saying he or she moved or required this case to be restricted. And the easiest way to determine if you're listening to this and you went through diversion, you're like, I don't know if my case was restricted, just go to the sheriff's office, get a copy of your background report, and you'll see on that case, it should say restricted for criminal justice or restricted for non-criminal justice purposes. So that's the sort of the third thing to make sure that, we get a dismissal we get the restriction where it's not going to be on your criminal history after you do all this. Because you don't want to do all this stuff, then all of a sudden people are finding it and people are using it against you. At that point, we could have just fought the charges. But, in my experience, pretrial diversions usually run, usually in certain counties, like Forsyth County, they have their own pretrial diversion officer, who's a person in the staff, in the solicitor's office, in the prosecutor's office, that runs all the cases. He's a great person, and basically he's making sure that you complete all of the conditions, right? He's not there to destroy your life. He's really there to make sure that you succeed at this program. Everybody wants you to. The prosecutor wants you to. Your lawyer wants you to. So that's the goal, help you through it, because you're certainly going to have questions. Hey, how do I do this? What do I do here? And that's this person's job to answer those questions. Other counties, probation is the one who runs the diversion. So the same person who's making sure that a probationer, someone who pled guilty, is doing their requirements, is running your pretrial diversion. And I don't really like that as much, because they don't really, distinguish or differentiate you from the person who pled guilty. So it's not as good, but we're still watching them and we're still making sure that everything goes smoothly. But sort of you either get the probationer who's watching you, or some offices have their own pretrial diversion coordinator, and that's sort of the gold standard in my opinion. And lastly, I wanted to mention, pretrial diversion generally lasts between 6 and 12 months, right? And now there's exceptions for everything, but what we see typically is a case that'll last a minimum of 6 months and a maximum of 12 months. So if you do everything you're supposed to do, there's no violations, your case could be dismissed and restricted in 6 months. But if you sort of need more time, then the case will go for another 6 months, giving you a total of 12. So that's this podcast on pretrial diversion. Please email me if you have any questions, aj@georgiacrime.com, or you can respond on this podcast or send me an Instagram or a tweet, and all will be well. So if you have your pretrial diversions, make sure you go to your local criminal justice agency, your local sheriff's office, get a background check, and just make sure the case was restricted. And that way you can go on living a crime-free life with zero criminal history. Take care.